All right, I'm coming back with part 2 of my video log. This is the situation now in this document here is the state of Maryland versus Anthony Grabber. And he was the gentleman that was riding his motorcycle and was pulled over by an undercover state trooper. He was charged with numerous traffic violations and wiretapping. You know, like the secret recording devices and so forth. He went to court over this matter, and the judge dismissed all the charges except for the traffic infractions. And as I read through it, the judge is highly skeptical. He's highly skeptical of the state's arguments for the wiretapping device. You know, it's ambiguous to say the least. You know, because a cell phone could be construed as a legal wiretapping device, and everybody owns cell phones. You know, so the law is overly vague. You know, that's what I gathered from reading through this document, in my opinion. And at the end of the ruling, it goes on to say a final observation. It says, those of us who are public officials are entrusted with the power of the state are ultimately accountable to the public. When we exercise that power in public fora, we should not expect our actions to be shielded from public observation. And it says, see State v. McCray. And I decided to use that case, and it goes on that the judge he went on to dismiss the criminal, like all these crazy criminal charges that the state of Maryland brought against this gentleman. In the next document is a United States Department of Justice statement of interest. And it's in the case of Mr. Sharp out of Baltimore versus the Baltimore City Police Department. Just reading this document, just the first paragraph, should clear up to police departments all across America that citizens have a right to videotape their actions and, you know, to document, videotape, photograph, and so forth. As long as they're not interfering, the police should not be hostile or so forth and arrest people. I'm going to read the first paragraph of the Department of Justice Statement of Interest. These are not my words. I'm reading word for word from the document. Statement of Interest of the United States. This litigation presents constitutional questions of great moment in this digital age. Whether private citizens have a First Amendment right to record police officers in the public discharge of their duties, and whether officers violate citizens' Fourth and 14th Amendment rights when they seize and destroy such recordings without a warrant or due process. The United States urges this court to answer both of those questions in the affirmative. The right to record police officers while performing duties in a public place, as well as the right to be protected from the warrantless seizure and destruction of those recordings, are not only required by the Constitution. They are consistent with our fundamental notions of liberty, promote the accountability of our government officers, and instill public confidence in the police officers who serve us daily. The United States is charged, this is the second paragraph, the United States is charged with enforcing 3 civil federal rights statutes that prohibit state and local law enforcement agencies from engaging in conduct that deprives persons of their rights under the Constitution and laws of the United States. One of the provisions that the United States enforces is the police misconduct provision of the Violent Crime Control and Law Enforcement Act of 1994. And it goes on to say 42 42 U.S.C. 14141, which authorizes the Attorney General to file lawsuits seeking court orders to reform police departments engaging in a pattern or practice of violating citizens' federal rights. The United States also enforces the anti-discrimination provisions of the Omnibus Crime Control and Safe Streets Act of 1968 and Title VI of the Civil Rights Act of 1964. Together, these three provisions prohibit discrimination on the basis of race, color, sex, or national origin by police departments receiving federal funds. Because of these enforcement responsibilities, the United States has a strong interest in ensuring that citizens' rights under the First, Fourth, and 14th Amendments are not diminished when they record police carrying out their duties in a public setting. Accordingly, the United States filed this statement of interest pursuant to 28 U.S.C. 517. That is just the first two paragraphs of the United States Justice Department throwing their hat into the ring on this issue. So the notion that police departments are having a gray area, like they don't know if people can record them or not. They say they can seize. I'm using quotation marks with the word seize video, cell phone video or photographs or your cameras and so forth as evidence of a crime. I think that's straining. Like reading just what the Department of Justice had to say, that's a stretch. My reading is that they need a warrant. They have to be as least intrusive as possible. In the Department of Justice, they go on. This is my second part of this video log for this, and I'm doing this log as a service to Prince George's County residents, and to try and help the police department, as crazy as that sounds, to try and help them understand that, hey, you have to respect the Constitution. People have these rights. These are rights that are affirmed in the Constitution, and the courts have reaffirmed them, All right, so this is part 2 of my log. I'm going to cut off, and I'm going to come back, and I'm going to do section 3.